What if you discovered that a financial penalty that you paid years ago was actually charged in error? Most people assume that once the IRS cashes your check, that transaction is final. The government rarely calls back to say, "We made a mistake. Here's your money back." During the COVID-19 pandemic, millions of taxpayers faced unprecedented disruptions. Businesses closed, supply chains broke, and normal financial rhythms were shattered. Amidst this chaos, many taxpayers filed late, paid late, or missed estimated tax payments. And the IRS, operating under its standard automated systems, assessed billions of dollars in penalties and interest. Taxpayers paid these amounts, assuming they had no choice. They absorbed the financial hit, internalized the stress, and moved on. But a recent federal court decision has fundamentally disrupted that assumption. It suggests that the IRS may have lacked the legal authority to assess certain penalties and interest during the entire 3.5-year COVID disaster period. This isn't just a minor administrative adjustment. It's a potential seismic shift that could entitle tens of millions of taxpayers to significant refunds. But there's a catch. The IRS isn't going to just send the money automatically. You have to know it exists, you have to understand the legal mechanism, and you have to act before a rapidly approaching deadline. And that's what we're unpacking today. Hello, I'm Jovi Shari Brown, and welcome to the Sweet Spot Tax Podcast. In each episode, we take a deep dive into a Georgia Peach income tax sweet spot source document written by me. Guided by brief musical transitions, we'll explore 5 key areas: the deep dive, the psychology behind it, the sweet spot shift, actionable takeaways, and the clarity check. Along the way, we'll expand on the source document and explore the ideas, strategy, and questions behind it. Our goal is simple: to take complex topics and break them down into clear, practical ideas that are easy to understand and apply. Whether the topic is tax strategy, business growth, financial clarity, navigating IRS challenges, or decision making, the objective remains the same: to help you think more clearly and move more intentionally. Let's align with your sweet spot and begin today's deep dive. Let's dive into this. The foundation of this opportunity rests on the recent U.S. Court of Federal Claims decision known as Kwong versus United States. To understand why this case matters, we have to look at how the tax code handles national emergencies. Under Internal Revenue Code Section 7508A, when a federal disaster is declared, the IRS has the authority to postpone tax deadlines. In 2019, Congress amended this law to create a mandatory automatic postponement period for federally declared disasters. When COVID-19 hit, a federal disaster was declared starting January 20, 2020. That disaster declaration remained in effect until May 11, 2023. According to the court in the Kwong case, the plain language of the statute means that all federal tax filing and payment deadlines were automatically suspended for that entire duration, plus an additional 60 days. That extends the postponement period all the way to July 10, 2023. What does this mean in practical terms? The court's reasoning suggests that any tax return or payment due during the entire 3.5-year window was not legally late until after July 10, 2023. Therefore, the IRS should not have assessed failure to file penalties, failure to pay penalties, or underpayment interest for obligations falling within that period. The scope of this is staggering. The National Taxpayer Advocate has stated that tens of millions of taxpayers, including individuals, small businesses, corporations, and estates, were assessed these penalties. If the Kwong decision holds up on appeal, those taxpayers are legally entitled to a refund of the penalties and interest they paid. But here's the critical procedural reality. The IRS disagrees with this broad interpretation and has appealed the decision. Because the law is unsettled, the IRS is not automatically issuing refunds. To protect your right to a refund, you must file what is known as a protective claim for refund. A protective claim is a formal placeholder. It tells the IRS, if the court ultimately decides in favor of the taxpayer in the Kwong case, I am claiming my right to a refund for the penalties I paid. Timing is everything here. The statute of limitations for filing a refund claim is generally 3 years from the date the return was filed, or 2 years from the date the tax was paid. Based on the Kwong timeline, the deadline for filing these protective claims for the COVID disaster period is generally July 10, 2026. If you miss that deadline, your money stays with the government, regardless of what the appellate courts decide. So, what's the psychology behind it? Why would a taxpayer, knowing they might be owed thousands of dollars, fail to file a simple piece of paper to claim it? The answer lies in a cognitive bias known as learned helplessness. When people deal with massive bureaucratic institutions like the IRS, they often internalize the belief that they have no power. They assume the system is infallible and that fighting is a waste of energy. When the IRS sent those penalty notices during COVID, most people just paid them because they believed the resistance was futile. Furthermore, we suffer from information asymmetry. The tax code is incredibly complex. Unless you have a tax professional actively monitoring court cases like Kwong, you simply don't know what you don't know. The brain tends to discount opportunities that require navigating complex, unfamiliar systems. There's also the psychological weight of reopening a closed chapter. The pandemic was traumatic for many. Paying those tax penalties was painful, but it provided closure. Filing a protective claim means reopening that file, re engaging with the IRS, and sitting in a state of uncertainty while the courts decide. The brain craves certainty, even if that certainty means accepting a financial loss. Overcoming this requires a shift in cognitive framing. It requires viewing the IRS not as an infallible authority, but as a system governed by laws that sometimes the IRS itself misinterprets. We'll continue our discussion in a moment. First, a brief word from Georgia Peach Income Tax.
Financial success creates opportunity, but it also creates complexity. Tax decisions affect more than forms. They affect your cash flow, your business, your peace of mind, and your long term financial future. That's why the Sweet Spot Tax podcast is powered by Georgia Peach Income Tax, strategic tax advisory and IRS representation built for clarity. Whether you're planning ahead, facing an IRS notice, dealing with back taxes, organizing your business, or seeking a clearer path forward, Georgia Peach Income Tax helps you move from stress to strategy and from uncertainty to clarity. Visit www.georgiapeachtax.com to access tax calculators, educational resources, IRS tools, AI assisted insights, and practical guidance designed to help you make smarter financial decisions before money moves. If you're looking for strategic tax advisory, IRS representation, or personalized support, call 229 395 3625. And if you'd like ongoing education, tax insights, live discussions, and access to everything from free resources to premium and VIP tax strategy experiences, join the Sweet Spot Tax community on School. Because the goal isn't simply filing a tax return, the goal is making better financial decisions with confidence. Visit www.georgiapeachtax.com, call 229 395 3625, or join the Sweet Spot Tax community on School today. Georgia Peach Income Tax, protection, strategy, financial clarity.
Most people view tax penalties as a punishment for bad behavior. The real opportunity is viewing tax penalties as a legal assessment that can be challenged. That's the sweet spot shift. When you blindly accept an IRS penalty, you are relinquishing your financial advocacy. You are letting the system dictate the terms of your wealth. The Kwong case is a powerful reminder that the IRS is subject to the same laws as the taxpayer. The shift happens when you adopt a stance of proactive compliance. Proactive compliance doesn't mean just paying what you are told. It means verifying that what you are told is legally accurate. It means utilizing mechanisms like protective claims, first time penalty abatement, and reasonable cause defenses to protect your capital. By filing a protective claim under Kwong, you are exercising your legal rights. You are saying, I complied with the system, but I expect the system to comply with the law. This mindset transforms you from a passive subject of the tax code into an active strategist. It is a fundamental shift in how you protect your wealth. If today's discussion resonates with you, here are 4 practical actions you can take immediately. Number 1, review your IRS transcripts for tax years 2019 through 2022. Look specifically for failure to file penalties, failure to pay penalties, and interest assessed during the period of January 20th, 2020 to July 10th, 2023. You need to know if you have skin in the game. Number 2, consult with a qualified tax professional immediately. Do not attempt to navigate the Kwong ruling on your own. Have your CPA or enrolled agent evaluate whether a protective claim for refund, usually filed on Form 843, is appropriate for your specific situation. Number 3, mark July 10th, 2026 on your calendar. This is the general deadline to file these protective claims. Because transcript retrieval and analysis take time, you must initiate this process well before the deadline. Number 4, ask your tax professional about other penalty relief options. Even if the Kwong case does not apply to you, you may be eligible for first-time penalty abatement or relief based on reasonable cause. Never assume a penalty is final until all avenues of relief have been explored. We spent today's episode discussing the Kwong case, COVID-era penalties, and the mechanics of protective refund claims. But perhaps the bigger lesson isn't about a specific court case. Perhaps it's about the necessity of vigilance. Wealth is not just built through earning, it is preserved through defense. Every dollar you unnecessarily pay in penalties is a dollar that cannot be invested in your business, your family, or your future. The IRS operates on a massive scale. Mistakes happen. Interpretations of the law evolve. If you assume that the government's initial assessment is always correct, you will inevitably leak wealth. Strategic people do not rely on the government to notify them of their rights. They build teams of professionals who monitor the landscape, identify opportunities, and act decisively to protect their needs. They understand that in the realm of taxes, silence is often interpreted as consent. The Kwong case represents a unique window in time. It is a rare opportunity to potentially recover capital that was lost during one of the most difficult economic periods in recent history. But that window is closing. And ask yourself, am I actively defending my wealth against systemic errors, or am I passively accepting financial losses because it feels easier in the moment? That's today's clarity check. Thank you for listening to the Sweet Spot Tax Podcast. For more tools, resources, and strategic insights, visit www.georgiapeachtax.com. Join the Sweet Spot Tax community on School or call 229-395-3625. Again, visit www.georgiapeachtax.com. Join the Sweet Spot Tax community on School or call 229-395-3625. Whether you're looking for tax strategy, IRS representation, or greater financial clarity, we're here to help. Georgia Peach Income Tax, Protection, Strategy, Financial Clarity. Until next time, align with your sweet spot and move with clarity.